Please be seated.
Good morning. I hope everyone had a glorious weekend. Certainly had really lovely weather. Today is Monday, June 10th. Welcome to the First District Court of Appeals. We do have four cases. On the docket this morning. 3 are scheduled for argument. 1 has submitted on the brief. As I call your case, if attorneys can please identify themselves and their readiness to proceed. So the first case that we have is case number C230658, Karen Jones, Administrator, versus Mark Davis et al.
Your Honor, Dan Wardowski on behalf of the appellant, ready to proceed.
Allison.
Are you both going to be arguing?
Scott Keenan and Kevin Pitt on behalf of the City of Cincinnati and Mr. Mark Davis.
Okay. And are you both going to be arguing?
Just me.
Okay.
Mike Capel and Sarah Geiger on behalf of the
Okay, thank you. You anticipated that. Okay, very good. We'll talk about time when we loop back, okay? The next case that we have is case number C230449, Norton Outdoor Advertising, Inc. versus Board of Zoning Appeals, Village of St. Bernard et al. Okay. Thank you. Next case we have is in re JG, cases number C230612, 613, and 614.
Good morning, Your Honors. Margaret Kane on behalf of the appellant JG, ready to proceed.
Thank you.
Good morning, Your Honors. Norbert Wessels on behalf of the State of ready to proceed.
Thank you. All right. And the last case we have is State of Ohio versus Joel Wallace, cases number C220509, 51 and 510. This case has submitted on the briefs. A little bit of housekeeping. As you can see, we have a nice group of students here. We have a mixture of high school students and also interns that are working with various offices and with various county offices. Actually, more than meets the eye, so there's more students than what are here. We also have students that are watching virtually in the adjoining courtroom. We're going to take a recess midstream, and the students will be switching. I believe that, is that after the first case? Is that what we've determined? Okay, all righty. And just so the parties that are going to be arguing after this case, just know we'll be taking a recess. And attorneys for Norton can go ahead and proceed to the desks if you like during that recess, and then we'll pick up and then continue from there. All right. So starting off with Karen Jones versus Mark Davis. Good morning again. All right. If you want to come forward when you're ready. Would you like to reserve time?
I would. I'd like to reserve, so I'm not sure how we're going to do this procedurally since there's 2 arguments and we have 30 minutes. Did the court envision that we would have 2 oral arguments back to back or put them all together?
What do you mean 2 arguments?
So my colleagues moved to have 15 minutes each, and we have 30 minutes.
Correct.
Do you want me to just proceed?
Now I understand your question.
Sorry.
We would treat it like any other case, so you would reserve whatever you're going to reserve.
Okay.
Each one of them would have 15 minutes. They would have to determine who's going to argue first, and then you will have your reserved time for rebuttal.
Perfect. Thank
That
you.
makes sense?
It does. Thank you.
Yeah, I think it makes sense for everyone. I mean, it does. This is no different than any other case. They're just the appellee is being these issues are being argued by 2 different attorneys.
Sounds good.
Okay.
In that case, I'd like to reserve 6 minutes of time.
All right, but thank you for asking and clarifying that. Eddie, you can go.
Please, the court, Your Honor, my name is Dan Mordarski. I am here today on behalf of the family of Hans Jones. Mr. Jones died at the Rumpke landfill based upon the negligence and perhaps recklessness of the defendants. We are here today because the trial court granted summary judgment for all the defendants below. If the court doesn't have a preference one way or another, I would like to start with the Rumpke dismissal. The trial court granted summary judgment for Rumpke, and the decision highlights several errors that the trial court made. The trial court initially said that he could not determine what the duty was of a landowner to a customer who enters their land. The trial court made that determination based upon two things. One, that there was no OSHA citation, and that there was no expert to tell him what the duty was. That is error. The duty that a landowner...
Is it that he couldn't determine the duty, or was he saying that the duty was not pled?
Well, I think...
Or was it a combination of the two?
I think it was a combination of both. So there may have been sort of this pleading defect issue, although it's not really clear that the court indicated that in the entry. But Ohio law doesn't require any specific type of pleading. It's notice pleading. What it appeared that the trial court made the decision based upon was that there was no expert to tell him what the duty was. And there was arguments below by my colleagues saying that there has to be an expert, and since we didn't have an expert say what the duty was, that summary judgment is appropriate. That's not what the law is. The law is a landowner has a duty to people who enter their land based upon the classification of who that person is. Are they a trespasser, an invitee, or a licensee? That has been the law for forever, as far as I've been to law school and before that. The trial court didn't address the premises liability categories of the three people that could enter a land.
You argued this in the summary judgment?
We did,
Okay.
not only in the summary judgment motion, but at the oral argument. What my colleagues argued below was we didn't plead premises liability as a claim. And what we argued to the trial court below is premises liability is not a claim. The claim is negligence. Premises liability, that term, is a legal doctrine that determines what the duty is for a landowner. It's not a claim. It's not a separate claim. The claim is negligence. But the law in Ohio is that a landowner's duty is determined based upon who enters their land and what duty they owe to them. That's the duty that the trial court should have applied in this case. Had he done that, he would have recognized that Mr. Jones was a business invitee. Mr. Jones paid Rumpke to be on the property and dump the waste that he was there to dump. That makes him a business invitee, and the duty that a landowner owes to a business invitee is ordinary care. The trial court erred by not applying that or even looking at that analysis.
It seems like the trial court said the existence of a duty depends on the foreseeability of the injury.
So the trial court did err on the foreseeability issue as well, and in two respects. So the trial court talked about foreseeability and said this incident wasn't foreseeable because it wouldn't be foreseeable that somebody would be dumped on and trashed and then later had a cardiac event that resulted in the death.
Is that, let's say that the trial court made that determination, is that consistent or inconsistent with the record?
Which part?
The part that that it's not foreseeable because it wouldn't be foreseeable that people would be there.
Yeah, so it's interesting what the trial court did find. The law is that...
Right, but is that consistent or inconsistent with what was presented at that moment with the case with regard to?
So what the trial court did is determine that it was that Rumpke could not foresee...
Let me ask it a little different. I'm
Sorry.
sorry.
I'm trying to answer your question.
I'm asking more directly. Wasn't there evidence in the record that the purpose for this like 15-foot rule was because of the nature of the dump and that there's people and it's to protect the people and so on?
Sorry, now I understand your question.
Okay.
And yes, that is the evidence in the record, is that there is supposed to be, there is intended to be a safety distance between trucks. Because we know that if one truck's there first, their operator may be getting out to open their back latch and dump their trash. And so the next truck that comes in should be at least 15 feet away and parallel. And so what the trial court found is it's foreseeable that if somebody parks too close and at an angle, that somebody could get hit by a truck or could have trash dumped on them and injured. That part, he said, was foreseeable. But he said it wasn't foreseeable that then they would have a cardiac event and die later. That's a misapplication of the law. Ohio law says for foreseeability and proximate cause, you just have to determine whether the acts or admissions are likely to cause harm, not specific harm. We cite the Supreme Court case that makes it very clear that it is the foreseeability of harm and not the specific harm that matters when it comes to foreseeability and proximate cause. The trial court erred in determining that it wasn't foreseeable what the specific injury was, when the law only requires that it should be foreseeability as to whether there could be an injury or harm.
That seemed to be the main part of the trial court's opinion, was that it was not foreseeable that your client would end up having a heart attack.
That's correct.
Okay.
And that's just not Ohio law. The Ohio law is whether there could be an injury. He says, the trial court says in the entry, I as a trial court believe it's foreseeable that somebody could be injured when the truck backs up too close, could be injured when the trash, it gets dumped on them. And so that's all we need to get past summary judgment and get to the jury. The second part of proximate cause where the trial court erred is on medical proximate cause. The trial court ignored two medical experts, ignored a statutory presumption, doesn't address it at all in the entry, and the trial court determined as a matter of law that being trapped in the trash could not have been the proximate cause of this man's death.
How did the trial court get past the coroner's determination that this was an accidental death precipitated by the trash incident?
I wish I could answer that because the trial court doesn't explain how they got past that. The practical reality is the coroner determined that it was this event combined with his underlying disease that caused his death. Now, some of the arguments that we heard below was, well, maybe this event was a contributing factor, or maybe it was the final straw, but it wasn't the proximate cause.
In his deposition, the coroner provided some additional detail for his findings, but he never retracted from the cause of death, did he?
That's absolutely correct, Your Honor. And both in his deposition and then in his affidavit again, both under oath saying this was a cause of death. And the entry on the death certificate is fundamental and critical here because he lists two causes. The man's underlying disease, his cardiac disease, combined with, and it says physical and emotional stress. Now, both the coroner and our expert, Dr. Briel, explain why that happens. When people are trapped, our body releases hormones. Those hormones make your heart and blood vessels do certain things, like makes your heart beat fast and your blood vessels constrict. And for people who don't have the disease, they probably don't die. For this man who has an underlying disease, it did lead to his death.
So is this a dispute of material fact?
So it would be if they presented an expert to say that that's not the cause of death. That would be a clear fact issue. Here, the court just ignored the facts. You could call it a fact issue, or just the court just didn't look at two medical experts who said this was a cause.
It sounds like the court expected or said that the law requires Rumpke to anticipate a heart attack versus an injury.
Right.
That seems to be the problem.
Yeah, and so as far as like the regular proximate cause and foreseeability, that's exactly what the trial court did, which was
Right.
not Ohio law. From the medical side of things, there's two unopposed medical experts in affidavits and deposition testimony that said this was a cause of death. The trial court just did not address that.
So going back to the premises liability duty, I believe that Rumpke is arguing an open and obvious argument in response to that.
So that's interesting. That was not argued in their motion. So that didn't meet their Drescher burden of proof in the summary judgment motion. But they argued in the reply brief that it's open and obvious, yet with no citation to any facts saying it was open and obvious to this individual or to anyone else. This kind of turned into its own argument at the oral argument with the trial court, where we started talking about things that were never pled, never briefed. We didn't have an opportunity to address those things in the briefing. It came in the reply brief and then the oral argument. The practical reality is the law says open and obvious applies to static hazards, hazards that were there before the plaintiff entered the property. Here, this is a dynamic hazard. We cite the cases in the brief that says open and obvious doesn't apply to this situation where the hazard is created while the person's there. So again, there is this open and obvious discussion, which again is error because we didn't even talk about the actual duty of what the landowner owed to the business invitee, and then there's no evidence about what this person or any other person perceived to be open and obvious. We had the trial court saying, well, aren't there backup alarms on the truck, and so wasn't he going to hear that? Yet there's really no substantive evidence in the record to talk about what people would hear or how many backup alarms there are or whether that really provided notice. It just sort of came out, reply brief and oral argument.
Even if we agree with you, we still have to get over the issues with immunity. Would you agree with that?
Yes, Your Honor.
Do you want to address that?
I do, and thank you, Your Honor. So immunity is always a challenging issue because the statute is in some places not very clear. And then we have our Supreme Court who has interpreted the statute in different ways. The motor vehicle exception is actually pretty clear when you read just that section. It says a political subdivision is liable for injury or death caused by the negligent operation of any motor vehicle. That's what the statute says. That's what, when we all went to law school and learned that statutory construction, the first rule is if the statute's clear, the court applies it, doesn't construe it. This one has seemed to be construed in different ways by the Supreme Court and other courts.
And there's no argument as to whether there's a motor vehicle.
Correct.
The issue is whether
No
it's
dispute
being
that it's a motor
operated.
vehicle, right. What we focus in on is this word operate. Whether the defendant was operating a motor vehicle that caused this death. So operate, as you probably saw in the Supreme Court cases, has taken a twist and turn with the Supreme Court applying criminal statutes and criminal definitions to civil statutes. But the practical reality is the Supreme Court has each time said operate means to cause or have caused movement of a vehicle. A have cause is critical here because the trial court interpreted it as because the vehicle was stopped, there cannot be an operation because the Supreme Court says you have to be moving. We argued, both in the briefing and at the oral argument, that the defendant had caused the vehicle to move. They backed up at an angle too close. That was the negligence or recklessness. The trial court got lost in this thought of it can't be the movement that happened before the event. It has to be at the same time. Well, we know that's not what the law is. When you look at the cases and cases from this court, when they're applying the actual criminal statute that the Supreme Court adopted, there are cases where people had moved their vehicle, but when they were arrested or received a ticket, they weren't moving at the time. The people
You did argue negligence in two ways. You said it was the backing up too close at an angle, and then the dumping, right? And it seems to me like the trial court was focusing on just the dumping piece.
Yeah, but the practical reality is if the person backs straight and is not too close to the other person, the dumping doesn't harm anybody. That's what you're supposed to do. It's really the backing at an angle and being too close. If you back at an angle, but yet you're not too close, you probably don't injure the person next to you. If you are too close, but you're not at an angle, you probably don't injure that person next to you. The record is pretty clear as to why they have that 15-foot rule between the trucks and why they should be parallel is for this very reason. So the negligence in moving back and at an angle is really the crux of the negligence and the recklessness. And so when we talk about the immunity to the city, the O2B1 exception, the motor vehicle exception, is what applies here because we have a negligent operation of any motor vehicle. We have a negligent backing at an angle of a motor vehicle. That is what led to the incident that caused the death.
So are you conceding that the dumping is not the movement of the vehicle? In other words, the movement of that bucket is not movement of the vehicle?
So that's a great question.
Or do you still believe that also can be movement of the vehicle?
I still believe it can be movement of the vehicle. And when you read the Supreme Court cases, they talk about not necessarily movement forward or backwards, not driving the vehicle, it's movement of the vehicle. And so, we do have arguments in here about an old case from the Second Appellate District that didn't involve a trash truck, but they put a lift on it and all this kind of stuff.
You're talking about the wreck case.
The wreck case. The practical reality is the operator was moving that vehicle when it was pushing the trash out. The vehicle was not moving forward, but the operator had to be in the driver's seat, key in the ignition, engine on, had to have the shifter in neutral, and most importantly, he had to operate the switch. The testimony is pretty clear. If he takes his hand off, everything stops. So he is actively operating that vehicle.
And counsel, something in the vehicle is actively moving to propel the trash out of the garbage truck,
That's
correct?
exactly right. So this is not a static condition. Things are moving, and the operator is making it move. So I believe there's two types of operation here. There is the negligent backing at an angle, and then there's movement of the blade that pushes out the trash.
Does the change in the statute and the elimination of the public highway component do anything with respect to your argument about movement?
So I think it does in some respects, because the state statute that we now have was passed at the same time that that municipal statute was repealed in rec. The practical reality is the legislature had the opportunity to look at both the rec case and the statutes and other municipal immunity statutes at the time when they were developing the state statute. They had the opportunity to say, we're going to limit this exception to movement on the highway. They didn't do that. They had the opportunity to see that in rec and in the old statute. They didn't do that. They broadened that. And in fact, they said, any motor vehicle, operate any motor vehicle. That was not in the first statute either. So what we could take from there, I believe, is a legislative intent to make that motor vehicle exception to immunity very broad. There's no exception for garbage trucks. There's no exception for equipment on trucks. They could have made this separate equipment part of the statute that came out of rec, but they didn't. So when we look back at the statute itself, we have to apply that statute. I think it would be incorrect for this court, the trial court, even the Supreme Court, with all due respect, to expand that statute to something that isn't in that statute right now.
When was the amendment?
So the current statute, 2744, gosh, I know my colleagues at the city will know exactly when it was passed. It was, I believe, in the 80s, but that statute became a statewide political subdivision immunity statute when there was statutes all around in different municipalities around the state. And so they repealed all of those individual ones and passed the statewide statute. And so, the legislature at the time had a lot of other versions to look at and case law to look at to determine what they want in, what they don't want in. And
So going back to the rec case, the statute at issue at that time had the language engagement in the operation.
yes,
And this is operate.
yeah.
Would you say that it's the same thing? Engagement in the operation is the same as operate?
Yeah, so some might just say that's extra words, but that's not what the law says. The law says every word means something. So engagement in the operation seems to me to be a more narrow view of things. Engagement in the operation on a public highway. That statute seemed to really focus on driving on a highway, right? Our statute doesn't have that. Our statute says negligent operation of any motor vehicle. That is a broad description of what type of incidents don't allow for immunity.
So what's interesting is if it were more narrow, in that case, we were dealing with sort of an auxiliary piece that was added to the vehicle that was operated separate from the operation of the vehicle, right?
Correct.
And then it was found not to be part of the engagement in the operation of the vehicle.
Right.
Which is a little different than what we have here.
Right. And there's a couple things that are important in that issue there is one, that really was a separate truck that somebody kind of put a piece of equipment on, and it didn't run off the engine, it didn't run off the truck itself. It was kind of this add-on thing. We don't have that here. That is very clear. The testimony from the people at the city is they don't buy the cab and chassis and then buy the Packer body and then somehow somebody at the city puts it all together. They buy a trash truck. There's no separate equipment here. It is the equipment. It is a vehicle. It is a motor vehicle under the statute. And so there's no separate equipment like there was in the wreck case.
Don't we have recent Ohio Supreme Court cases, though, that have held that this exception for negligent operation pertains only to negligence in driving or otherwise causing the vehicle to be moved? I mean, we do have, as late as 2019,
Sure.
cases that say that.
Yeah, thanks for raising that. And the issue there is, when we look at the Supreme Court cases that have addressed this, we've got the Doe case, which is the school bus, where two students, where there's a sexual assault by one student on another. And the plaintiffs argued that the bus driver's negligent supervision is operating motor vehicle. Supreme Court, not surprisingly, says, no, that's not operation, that's supervision. The next one is the Dudley case, which is a police officer responding lights and sirens to an emergency. That has its own separate immunity section that you can't excuse. They get immunity for lights and sirens to the accident. So in that situation, somehow they got to the Supreme Court on this argument that, well, we know he's immune for his response with lights and sirens, but our argument is your negligent training of him led to the death. The Supreme Court says, no, training is not operation of a motor vehicle. It's training. So then when we get to the final case that just most recently, that's State v. Wilson, it's a criminal case. It is the criminal defendant was charged with operating a motor vehicle on a suspended license. He's in a car, it's not moving, he's listening to the radio, and the Supreme Court ultimately says, you have to look at the context. You have to look at the context of what we're talking about when we say operate. In this situation, the context is we don't want people driving on the road when they have a suspended license. We suspended that for a reason. So look at the context here, and they said that was not operation because he wasn't moving the motor vehicle. He wasn't doing what we were trying to prohibit him from doing. So it's easy then to just take that quote and say, oh, well, you must be driving. But if you do that, you have to take the sentence that says context matters.
So are you saying in the Wilson case, if the vehicle had been found in the off-ramp of a highway, parked,
Yeah.
stopped,
Right.
listening to the radio, that maybe the outcome would have been different?
I absolutely do believe it would be different, and based upon the to cause or have caused movement. In that situation, there was no way to prove a man sitting in a parking lot listening to the radio without moving the car. There's no way to prove that he moved that. If he's on the off-ramp and passes out or for whatever reason isn't moving, yeah, then you can make an inference that it got there somehow and it was his operation which violated his
If we interpret the word movement to mean, as I think the city wants us to, moving the entire car, versus interpreting the word movement to mean, as I think you want us to interpret it, moving just a part of the vehicle, aren't we then putting the word driving back into the statute? Because moving the entire car is in effect driving the car.
Yeah, so that's a great point, because driving is not part of the statute. And so what we have seen with other cases is it sort of expands into this, well, he must be driving issue. But that's not what the law is, and that's not what the statute is. So to your question, the answer is, it is operate a motor vehicle. The Supreme Court says, in some contexts, that means moving the vehicle forward. And if you look at those three Supreme Court cases, look at the vehicles. One, we have a school bus. The only function of a school bus is to take people from point A to point B. The next one.
You have about a minute left, so I'm going to
sorry.
give you that. That's okay. I'm going to give you a minute to address the immunity on Davis.
Thank you.
Okay.
Yes.
How are we going to survive into reckless land so that, okay.
So I'm so glad you brought that up, because it really goes back to this court's decision in Franks a couple years ago, Franks versus Southwest Transit Authority, where this court said somebody asking for statutory immunity on summary judgment has a dual burden. They have to satisfy the Drescher burden, but they have to satisfy every element and prove at the summary judgment stage that we cannot prove every element of that statute. When we're at the trial court, it's our burden, but at summary judgment, it's their burden to affirmatively come forth and say, I was not reckless, and here's the evidence in the record to show that. What we do have in the record is evidence of recklessness. We have evidence that the drivers at the city of Cincinnati are trained about the 15-foot rule. They're trained about backing in parallel and not at an angle. And they're prohibited from wearing earphones or AirPods in their ears. We have in the record those 3 violations. The driver, Mr. Davis, admits he's got earpods in his ears. He's listening to a podcast at the time. That's a violation of the department regulations. He admits that he was 3 to 5 feet from the truck next to him. That's an admission of violating the safety rule. And then as he describes how he's backing up, he said he's looking at his rear cameras and he sees the truck in his rear mirrors. He doesn't see the landfill behind him. He sees the truck as he's backing up in the spot. We have at least prima facie evidence to get past summary judgment on whether he was reckless for violating those department.
To the judge, he didn't even analyze that, though. I felt like he just took, he said, city's immune, therefore Mr. Davis is immune.
Yeah. I think that's, with a lot of issues, that's kind of where the trial could.
Which is an interesting issue of law because the immunity, what gets them over the immunity is different.
Yes,
for,
it is.
Yeah,
Absolutely.
for the
And-
city than it is for Davis.
Can you briefly summarize the evidence that suggests that Davis was in fact the driver?
Yes. So what we do know is Mr. Davis admits he was there at the time. He was at the landfill. He was dumping on the working face at approximately the same time that this happened. We do know from several witnesses that it was a city of Cincinnati truck. We do know from Mr. Davis that he admits that he was 3 to 5 feet next to the truck that was next to him, which is a clear safety violation. His description of how he backed suggests that he backed in at an angle. So what we have is circumstantial evidence, and more than just a little circumstantial evidence, that he was in fact the driver.
So he doesn't have any recollection of dumping garbage on somebody?
Correct. He just left on his way. We deposed all of the drivers that were there at the same time. None of them have any recollection, but we only have one who's listening to a podcast violating the safety rules. So is it possible that a man did that, listening to his podcast as opposed to paying attention to what happened? Sure, that's a jury can make that inference.
I have a question with regard to the record based on this question that you were asked and your answer. As I recall, when I was looking at the summary judgment motions, and I think it was in the city's summary judgment motion, in the recitation of facts, there was a discussion that Mr. Davis had spoken to some Rumpke employees and had said that there was a city truck who had dumped this on him.
Yes.
So I saw that there, but it didn't seem to appear elsewhere.
Yeah, and so that's an interesting fact. There was some suggestion that might be hearsay. We believe that is satisfied by the excited utterance situation that many people described what a scary situation it was. And in fact, the man uses an expletive as he describes that guy dumped on me and felt like it was retaliation for Mr. Jones passing him right before he got on the work face and sort of taking his spot. And so he believed, it sounds like, that the other guy came next to him and kind of did it on purpose to say, don't do that to me again. So again, these are little pieces of the puzzle that we put together in front of the jury and allow the jury to decide if that's sufficient evidence. To allow the court to decide that, it's just simply error. Both of, or all of the defendants had the duty to point to the record and say there is no issue of fact. That did not happen here.
And that they're entitled to judgment as a matter of law. All right, thank you so much.
Thank you, Your Honors.
All righty, who goes first? Whatever you guys decide. I'm fine with whatever your decision is.
I'm standing out.
Okay,
Good morning, Your Honors.
good morning.
Here to talk a little bit about Rumpke's positions in this case. I do want to start, this is a question. I want to start with the pleading of the plaintiffs. And their complaint And my colleague mentioned whether or not there was a pleading deficiency. The only thing pled against Rumpke in this case was one sentence. The one sentence in the complaint, and their entire theory of the case until motion for summary judgment was one thing, right? It was that Rumpke negligently operated the landfill by failing to have spotters, proper traffic patterns, and/or visibilities for drivers dropping off garbage. So we proceeded along this for more than 2 years.
Counsel, doesn't that sound more like how the duty was breached than the duty itself?
Okay, so there are negligent landfill operations negligence claims, right? They're trying to now equate this as a premises liability case. Is that where you want me to go?
Sure, let's head there.
Okay, so those are different. First of all, we're talking about torts, not negligence, right? I mean, and how I know that is, I brought back my torts book from the first year of law school, right? And premises liability is nowhere near the chapter on negligence, right? I mean, it is the back end of the book, and they have different duties, right? So you talk about trespasser, invitees, frequent visitors, versus a basic negligence action. If they had pled a simple negligence action, which, again, they didn't really say, hey, Rumpke had a duty, Rumpke breached that duty, and there were proximate cause that caused the death of Ann Jones. They didn't plead that either, right? They simply pled negligent landfill operations against Rumpke. There are negligent landfill operations cases. To demonstrate that duty, you have to hire an expert. Okay, and there's case law not only in Ohio, which was the State X. Rel. Shaner case, but also Wisconsin and California that talks about if you're arguing a negligent landfill operations case, you need to have an expert to testify and establish that duty.
So you're saying that based on the way this was pled, you all assumed throughout the entire discovery process that they were just arguing negligent landfill operations?
Yes. There was never any kind of argument that this was a premises liability case until their response to our motion for summary judgment. And thus, the question that they now raise on appeal about whether or not we met our Drescher burden, about whether or not we raised the issue of open and obvious and whether or not we are entitled to summary judgment on the premises liability claim is a little disingenuous.
How would this have been pled then as a premises liability?
Sure. You would have simply said, hey, Rumpke's a landowner. Mr. Jones is a business invitee. Rumpke owned a duty to Mr. Jones as a business invitee, and that we breached that duty. That wasn't pled either, nor was it argued until the motion for summary judgment standard.
So they would have to specifically, in their notice pleading, say that Rumpke owed a they would have to spell all that out, and they can't just say it was negligence.
I mean, they could have said general negligence, and we could have asked for a more definitive statement. They didn't do that. They gave a more definitive statement. They said negligent landfill operations. They didn't say premises liability.
Where was the more definitive statement?
We didn't need to file one because they had filed.
Oh, because you're saying it was in the pleadings.
Yeah. On this one, the one claim again.
So you were never confused by this because you thought this was just one negligent landfill operation.
That's correct. We were proceeding along the fact that they were pled a negligent landfill operations case. They hired a landfill expert. For reasons unbeknownst to us, they never disclosed a report from Neil Bolton. We hired one as well. We hired David Moulter. So we were prepared to respond to, a negligent landfill operations case. They never proceeded to provide an expert report as to theories as to why there should be certain rules or why the landfill was negligent in its operations. And so, but if we want to go down to
And so what does that, let me
Right.
just walk through that case. So what does that case look like from your perspective? Like you would have an expert that would say, we have these types of rules to prevent these types of problems, and we line up trucks this way and they empty this way.
Sure. So obviously, the real question is what's in the mind of a jury, right? What can a juror reasonably understand without bringing an expert into a case? And so we would posit that, look, a working face of a landfill is something beyond the scope of what a reasonable juror would know. A working face of a landfill is large, right? So it is 12 to 14 trucks can back up at any one time. But then you also have, and these trucks are not normal, these are all garbage trucks, right? So they're up to 60,000 pounds. Sometimes there's semis, sometimes there's roll-off trucks, like Mr. Jones is driving, which is one of those boxes on the back where you have to open the gate itself to let the contents out. There's the residential garbage trucks, there's front-load garbage trucks, and then you have these large bulldozers, and not normal bulldozers, right? Blades that are 15 to 20 foot wide because they need them to push back the garbage that's being ejected out into the back, and there's these large compactors back there. And so what plaintiffs have tried to allege with the spotter arguments is that, hey, you should have had a spotter over there, like being like an air traffic controller waving in these trucks into these spots.
So they allege that there used to be spotters.
Well, there are spotters. There still are spotters. But spotters aren't there for those purposes. And if they would have had an expert testifying about what spotters are used for, they wouldn't understand that. Right? Spotters are there for efficiency purposes only. They're not out there. It's too dangerous for a spotter to be in a working phase. Remember, we have 14 trucks, and they're not all backing in unison. They're coming and going, and there's bulldozers pushing back garbage, and there's compactors back there. So if a spotter to be back behind would be just terribly unsafe, right? Because we have large bulldozers, we have compactors, we have trucks. You couldn't also be in front of the trucks because it also, all these trucks moving in and out. Inherently dangerous area. Spotters at the front of the line, right? So if you have 14 trucks backing into a working phase, and then down the Hall Road between 10 a.m. and 2 p.m., there's a backup.
And so this may be outside the record, but
Sure.
in the facts of this case, if a spotter had been present and a city truck had pulled in violation of the rule, what would the spotter have done to address that situation?
Spotter could do nothing. That's what I was trying to get to. A spotter's more than a football field away, okay? A spotter's at the front of the line while the truck's going down the Hall Road, backed up.
So they just tell people, you go here, you go here.
That's
you go
exactly
here.
correct.
Yeah.
All they're saying is, hey, there's a spot, looks like there's a spot going up over there, you can go to that next position, right? They're not down there to keep truck separation or anything like that. It would be too dangerous for a human being to be walking around at the working face like that.
And so this is the case that you thought that you were putting on, that the presence of a spotter was not necessary because the spotter would not have been able to prevent the situation that ultimately occurred.
That's correct. This is a negligent landfill operations case, and they would need an expert to testify as to what a spotter should be doing, or what proper traffic patterns should be there, or what truck separation, what rules or recommendations or regulations
What was the
exist.
negligence that was argued beyond that at the summary judgment hearing?
Could you say that again?
What was the negligence
Oh,
that was argued beyond that
then they also,
by the plaintiff at the summary judgment hearing?
well, then they morphed into this premises liability theory at the motion for summary judgment stage, right? So then they came into and said, hey, this isn't just a negligent landfill operations. What they then argued and switched because they realized they didn't have an expert was, this is a premises liability case. And Rumpke is aware of it. They know it's a dangerous place, and they have a duty then to warn because they know it's a dangerous place. Everyone knows it's a dangerous place. Every person.
So what's the response to that? So, I understand
Sure.
your argument on the plating.
Yeah.
But if you, responding to that,
Yes.
what's
So,
the duty, what's the issue?
sure, a landowner does have a reasonable duty to warn of known latent or hidden dangers, right? There's nothing hidden or latent about the dangers of the working phase.
So your response is open and obvious?
Yes.
Okay, and they're saying that that doesn't apply to a dynamic situation.
Well, every person that's testified in this case have talked about the dangerous nature of the landfill, right? I mean, we talked about SES's, his coworker, Josh Short, testified it's a dangerous place. We have City of Cincinnati employees testifying they don't get out on the working phase because it's a dangerous place. And so we don't have to warn about known dangers, right? Everyone knows, even Mr. Jones had discussions with Mr. Short about the known dangers of a landfill working phase. And so, you have to warn about known latent or hidden dangers. Again, this is not a latent or hidden danger, so I disagree with their
So this would
interpretation.
never be a jury question on whether it's open and obvious?
No, I don't think so, Your Honor. I think the question here is that as a matter of law, everyone is testifying. There's no genuine issue of material fact actually in evidence that suggests it's anything but a known hazard. That is a known dangerous area, right? And that it's not, there have been no allegations by plaintiff this is a hidden or latent danger.
So what you're saying is because it's an obviously or known hazardous area that everyone has a duty to proceed with caution.
That's correct.
Okay.
What about the issue that Rumpke had noticed other safety guideline incidents? I don't know if there's ever been a trash dumping incident, but
There's not.
there's been
There is
other
not.
safety incidents, right?
Sure. I mean, you're talking about, so we looked at, in Discovery, we looked at the 5-year period preceding this accident, right? There's about 500,000 loads dumped at the landfill on an annual basis. And they asked for any backing incident on the landfill. So we looked and said, well, so in the last 5 years, there have been 2.5 million separate loads at the landfill. There were 8 incidents in which there was a backing incident at the working phase. all of those were simple, small property damage. None of those included
Where
property.
they ran into each other.
Yeah, there was a small, 8 incidents out of 2.5 million, right? So let's do the percentages. We're talking very, very small. And none of them included a personal injury. And so, and in fact, the testimony in front and presented to the court through the depositions throughout the case, no one ever had knowledge of any other incident in more than 30 years now of someone else being dumped on by garbage by another truck on the landfill, right? This is a act of negligence by the city of Cincinnati driver, potentially, dropping or depositing garbage on the back of Mr. Jones over an alleged, road rage incident on the Hall Road. So this is not something that you can have. There's no notice or foreseeability of Rumpke of this type of injury. It still hasn't happened to this day since this accident either in 2020. So in more than
This
35
type,
years.
I mean, do you agree with the trial judge's conclusion that you would have had to have notice of a heart attack?
No, I think you've been. No, I'm not going there.
Okay.
Right? No. I think the foreseeability is really not notice of a specific injury, as plaintiff has said, or the specific heart attack. The notice is, do you have any notice or foreseeability of this type of accident, right, or this type of injury? And this it doesn't happen, right? I mean, in again, more than 2.5 million loads in just the 5 years, there's been no personal injuries in a landfill. And in more than 30 years, no one's ever been dumped on by garbage.
But you're saying it's open and obvious that this is a dangerous place. I mean,
Yes.
trucks are dumping. It's a chaotic situation.
It is dangerous, but we're talking about professional drivers too, right? I mean, these are people that are all independent. These are not driver's license that you and me hold. These are driver's license people that have extra training. They get training not only on to get a commercial driver's license, but they also get training on a monthly basis. On a every other month basis, they get extra safety trainings, right? And so they are constantly being improved upon. And driver observations, we don't do any of those things. No one's observed you or me or the court drive before and say whether or not you should make changes. So these are professional drivers that are doing this, and that's why you don't have these incidents, right?
What I
Because
find
these are
interesting about your argument, like your answer right now, is most of your argument has been facts,
Yes.
information, as opposed to arguments. And the reason I raise that is not for what you're thinking. Your argument is it wasn't pled, and thus we didn't have an opportunity to present it.
on the premises liability arguments, yes, and the court didn't address that on their decision, Your Honor.
Understand what I'm saying?
Yes.
Okay.
So, I mean, that's one part of it, right? That's the premises liability question.
Right.
The other, we maintain, look, we're entitled to summary judgment on any of these potential theories, right? One, they could never establish a duty of negligent landfill operations. Two, they didn't properly plead a premises liability case, but even if they did, were allowed to bring this in at the last moment, we still are entitled to summary judgment because, again, there's nothing here about this. There was no known latent or hidden danger that we failed to warn about under the law.
What is the open and obvious danger specifically?
It's just a dangerous, because of the size, right? We're not talking about a car that weighs 2,000 pounds. We're talking about trucks that weigh 60,000 pounds with their loaded trash. And so you're talking about the inner movements of these huge, large trucks, compactors, bulldozers, et cetera, that it is just an inherently dangerous area. If a car backs into you at 5 miles an hour, my guess is you were able to move out of the way. Or if it does hit you, it's probably not a major injury. A truck that weighs 60,000 pounds backs into you, it's a significant injury.
Okay, so the danger is more connected to the comings and goings of the large vehicles.
Yes.
And less so the trash itself.
The exposure to trash? I mean, it's the trash itself is not, you don't want to be back beyond where the trucks are going, right, where the compactors are. But no, it's not a hazardous waste situation, if that's your question.
All right.
We only accept municipal solid waste at Rumpke Sanitary Landfill. Okay. Other questions? I'm not sure what my time is at this point.
I'll give you 30 seconds to wrap up.
30 seconds. Thank you, Your Honors. We believe, that even under the de novo standard, if you look at all the facts and allegations in this case, the plaintiff simply cannot establish, one, that can't establish a duty on negligent landfill operations, cannot establish that we somehow breached a premises liability claim that was never pled. And we also, believe that there's no proximate cause between Mr. Jones's death and our acts at the landfill.
And let
Thank
me
you.
just make sure that, are there any other questions from the panel? All righty, thank you.
Thank you, Your Honors.
Good morning, Scott
Good
Hean on
morning.
behalf of the city and Mr. Davis. Let's start with Mr. Davis and the fact that there is nothing in the record whatsoever that points to Mr. Davis, if this happened the way they described in their complaint, that he's the person who did this. There were at least 3 other city trucks up there. And the only evidence that we have pointing to any truck that did this is that it had a city logo on it.
Why isn't this a factual issue for the jury to decide?
Well, that would be going to this court's mid-century versus, I think it was Stites, where there were the 4 people on a balcony smoking. And one of those 4 dropped a cigarette butt in a plastic leg of a chair. And that chair caught on fire, and the insurance company wanted to go after whoever caused the fire for damages. They couldn't say who actually put the cigarette butt in the chair.
We have a little bit more here. I mean, in that case, you had multiple people, and anybody could have done it because multiple people were smoking and so on.
Sure. And here there were multiple city trucks that were at the landfill at that time that were all dumping. And under the facts are very, very, a cigarette dropped in a chair. Here it was trash dropped to the landfill. But we don't know who the person driving and operating that vehicle was.
How would you address
now.
my question earlier with regard to the facts that are discussed in one of the summary judgment motions of Mr. Jones, what he had stated to Rumpke employees after the incident had
He
occurred?
identified it as a city truck and a city driver. He couldn't say that it was Mark Davis. He didn't know one. The closest we got to identifying who the driver was, someone said it was a black guy. And that, they took the deposition of everybody who was up there for the city at that time. All of them are African American.
Taking the facts in the light most favorable to the plaintiff, as we are required to do, why is there not circumstantial evidence that Davis was the driver, given the testimony from Rumpke officials that he was the closest in time coming in, and giving his own testimony that he did in fact back in at an angle, and the other factors that the plaintiff has cited about his driving?
I went into a little bit more detail on this during the arguments below, but the actual timeline, when they rely on the fact that it had to be him because he was the closest in time, that it doesn't time out properly. But again, when we go back to Stites, that was a summary judgment case where this court said, when you get, it might be enough to get past motion to dismiss or judgment of the pleadings. You're allowed to, you don't have to specify who it was in your complaint. But once you get to the summary judgment stage, at this point, you need to be able to point to something where we're no longer guessing. And here, I'll readily admit that there is a genuine issue of material fact if a city truck was involved. There's no facts whatsoever that say it was Mark Davis that was driving it. It could have been any one of our trucks that were up there that was parked next to Mr. Jones's truck.
Did anyone else admit that they backed in and could see the other truck in the rearview mirror, and that they were 3 to 4 feet from the other truck? Did anyone else describe that backing up behavior?
They all described backing up into the spot where they dumped. None of them recalled seeing a truck like Mr. Jones's truck. Mr. Davis recalled seeing what he thought, he described it as a sludge truck, but in his mind a sludge truck was one of the ones that has like the canister, kind of like, I think people clean out the portalets and stuff like that, which wouldn't be getting dumped there because they don't take that kind of waste.
Would you agree that the trial judge didn't analyze Mr. Davis's liability separately from the city's?
He went straight to the immunity.
The city's immunity.
The city's immunity, which then dovetails into Mr. Davis's immunity. On that, the motor vehicle exception is the relevant one here. As far as our burden, no one disputes that solid waste collections is a governmental function. That the Supreme Court decided that in '57, in a case where someone threw garbage into the truck and it hit somebody, and they said, that's collection, disposal of solid waste, that's governmental function. Now, that motor vehicle exception that existed then is different than it is today, which is why today, once we have identified that we have immunity, we look at the exceptions. And the relevant exception here, the only one that anyone has argued could apply, is the motor vehicle exception. And the motor vehicle exception, it is negligent operation of any motor vehicle, and it's that negligent operation of the motor vehicle that matters. When you look at rec.
Before you go there, I want to
Sure.
bring you back to where you were a minute ago, because I understood you to say that there's no doubt that it was a city vehicle.
There's a
but
genuine issue of material fact as to
Okay.
whether it's a city truck. And
Okay.
that's why we get to the immunity analysis. If that didn't exist, then we
Okay.
wouldn't know who it was.
Okay.
But since we.
I think you're anticipating where I'm going, right?
Maybe.
And that is, on that argument, if we were to agree with you, then it doesn't get the city out yet.
We need the immunity to get the city out. But Mr. Davis simply should not be in this case, because at this point, we'd be asking a judge or a jury to guess and say, well, he was up there, maybe it was him, and point a finger at him without any evidence saying it was truly him. On the immunity exception, when you look at rec, there are not very many cases on this. Rec and Bergman are the two cases I was able to find that involve solid waste operations.
Before you get to rec, because I know you're going to talk about the actual dumping, can you address their argument about the negligence and the parking at an angle? Because it seems to me that if that's enough for movement, then the city's not immune.
So when the motor vehicle exception's purpose, when you look at the cases that apply it, is for general automobile accidents like happen right outside this building every other day. That's what that exception is for. So if someone's negligent driving, bad driving, two people run into each other, okay, the state has decided that's something that, the cities and other municipalities and political subdivisions aren't going to be immune for. When you get to this, though, and State versus Wilson that came out of this court and then to the Supreme Court, it's actually a really good set of facts here to explain this, is that there's moving a vehicle and whether or not that causes the injury, or if it's the equipment that's on the vehicle that causes.
So they're saying, one of their arguments is that moving the vehicle, negligently driving and parking the vehicle at an angle, but for that, this would not have occurred.
Nothing about backing into that spot caused anyone any injury. The injury was not caused by the movement of that vehicle. It was not whether it was how it was backed in or how it was pulled away. The Copen case from the Supreme Court.
What caused the injury? What caused the injury?
Their allegations is that it was the trash being dumped on Mr. Jones that caused the injury. It had nothing to do with, how.
It had nothing to do with the parking too close at an angle?
That did not cause the injury.
But
the
if
trash caused the injury.
If he parked according to the guideline, the 10 to 15-foot guideline, straight back, when he dumped the trash, it wouldn't have gone on Mr. Jones.
That may be the case, but again, as you just said, it was the trash that caused the injury. So where that truck was, had someone looked back and seen Mr. Jones behind there and said, oh, there's a person there, and then dumped, that would obviously be a purposeful thing. That would be a problem. But there was no, if they had when backing in it too close, if they had hit Mr. Jones, whoever it was, if whoever was driving that truck and backing up had struck Mr. Jones with the truck, that would have been in the operation of the motor vehicle.
So your position is we have to separate out each of these acts when we look at causation?
Yes, that is what the motor vehicle exception requires, is it requires that the injury be caused by the operation of a motor vehicle, which means either moving or having cause to move a vehicle. And I know they've gotten on to having cause, well, you had to back into that spot to cause the injury. And when you look at Copen was the case from the Supreme Court where there was an ambulance, I think it was, it pulled up next to someone. Something was wrong with the engine, and it sprayed some type of fluid on her, and then they drove away. And the argument was, you driving away is what caused me my injury. If you'd actually treated me, I wouldn't have been injured. And the Supreme Court said, no. The injury happened when that vehicle was stationary. That was not caused by the movement of that vehicle.
Is it because it was stationary, or was it because it was some liquid that was expelled from the vehicle that had nothing to do with operating the vehicle?
Well, it was the engine that was operating that caused some type of liquid to shoot out. If that car had been off, or ambulance would have been off, nothing would have sprayed out of it.
What's interesting here is that you have a truck that's being used for precisely what the truck is intended to be used, and in the using of the truck as intended, the injury takes place. So this is so different than the wreck case, where you have an add-on piece of equipment.
I don't know that it was an
That's
add-on
not a
piece.
necessary part of the vehicle.
There's nothing in rec that says it was an add-on piece of equipment. And the only testimony here as to how the vehicles, the only expert testimony on this came from Eric Benzing. And he said that, yes, they come to us pre-assembled, but that's just how they come to us. There's still two distinct parts of a city garbage truck. There's the motor vehicle part that is what you would think of as a normal vehicle. It's the transmission, the chassis, it's got the cab where you drive, and then there's whatever gets put on the back. And he said that every one of the city's trucks could easily be repurposed. You take the Packer body off, and you could install whatever you wanted on there. You could make it a cement truck. You could make it a tow truck.
So I want to make sure I understand this piece of your argument. Are you arguing that the mechanism that pushes the trash out is not a motor vehicle, that these are two separate features of the truck? Or are you arguing that when the operator or the person presses the button and puts the truck in neutral to push the trash out, that that's not operation, or both?
When the trash is being expelled, the part that is being operated is the Packer body. Now, the city uses different kind of trucks. We have Mack, we have Freightliner. McNeilis is a different company that manufactures the Packer bodies. So it's two different companies that make these parts. When the trash is being expelled, the only thing that's being operated is the Packer body. The engine, the engine, yes, the engine is generating the power that powers the hydraulics. But that would be, like in Wilson, the engine was generating the heat. That wasn't operating the motor vehicle. That was operating the heater maybe, but it wasn't operating the motor vehicle. And so again, there is, I mean, I realize that maybe it's drawing lines, but these are the lines that the legislature has chosen to draw. And they have said that to defeat immunity, the immunity exception requires operation of a
They don't
motor vehicle.
define operate. Operate's not defined, right?
No, it is not statutorily defined.
It's
So that's
been
why we
judicially defined
It
in the
has.
context of OVI law.
only in Wilson. It's also been defined when you look at the other cases in Doe versus Marlington. That was where a student was molested while on the bus while the bus driver was driving the bus, and they said that wasn't the operation of the motor vehicle. That your supervision didn't have to do with that. In McConnell versus Dudley, the argument was that it was negligent hiring of a bad driver, and they said that's not operating, even though he was operating the vehicle when the injury occurred.
Those are very different cases than what we have here, right?
Well, and that's why we go back to Reck and Bergman, which are the two cases where there were similar facts involving solid waste
And
operations.
that was before the amendment, right?
Reck was, Bergman was not. And when you look at the amendments, when we moved from 704 to 2744, the changes were really minimal and would not, if the old law would have been in effect here, if 704 had been in effect, we would have been absolutely immune because it didn't occur on a public highway.
Right.
So now they've changed it, say, okay, on a public highway, and they expanded it to cover all political subdivisions, whereas before it didn't.
That change seems fairly significant, at least in terms of the geographic location of the vehicle, right? Because at the very least, it expands municipal liability to private property.
Yes.
At the very least. But one other interpretation is that it could also be expanding liability to a broader range of things that happen with vehicles. I mean, the focus on a public highway has to be driving. It has to be. That's what you do with a car on a road. When you take that term away, it is possible that the legislature could be focusing this statute on activities with respect to a vehicle that don't involve driving.
The former, and I'm sorry, I was saying 704, it's 701, but the former immunity exception was caused by the negligence while engaged in the operation of any vehicles upon the public highways of this state. Now it is caused by the negligent operation of any motor vehicle by their employees. And there was a recent case, State versus Fork, out of the Ohio Supreme Court, which I only looked at really over this weekend, which involved a utility vehicle. and where they split out the definition and said, hey, utility vehicle is different than a motor vehicle. When you look at 451101, where they define motor vehicle, they define vehicle, they define motor vehicle, and then they list all the other kind of things. When you get down to RRR, a garbage truck is defined separately. It is defined as a vehicle used in solid waste operations. And if we're going to, this was not something that was argued below, because quite honestly, the
You're
case
gonna say
didn't
it's
come
not a
out.
motor vehicle?
That with the way they looked at things there, that the motor vehicle exception today says motor vehicle, and the definition of sanitation truck below, or in RRR, is a vehicle, not a motor vehicle, but a vehicle. And the legislature has, for whatever reason, chosen to split those things out. Now, again, I recognize that was not argued below. It might be something that you need supplemental briefing on, but it is something I only discovered over the weekend when I looked at this. Regardless, though, regardless of whether it is a vehicle or motor vehicle or not, the injury that occurred here was when that Packer body was being operated, and the Packer body is separate and apart from the motor vehicle.
So let
They
me
can't
ask you
be
this
operated at the
question
same
based
time.
on what you're arguing. City bus, okay, is at one of the bus stops, okay? So it's not moving,
Correct?
okay? Opens up the door.
Mhm.
There's someone right there. Person gets injured by the opening of the door. Are you saying that then they not engage in the operation of a motor vehicle?
I honestly don't know, because I don't have an expert telling me exactly how buses operate, and I don't want to sound like I'm being pedantic, but the thing is that, when I needed an expert and to talk about how these trucks operate, because it's not common knowledge how they work. I didn't know when I started this case that they're two separate things. I didn't realize that, I always saw McNeilus across the top of the truck.
Well, we
Oh,
could
they're all
make that
McNeilus trucks.
hypothetical even simpler and just talk about a city-owned car.
Okay?
And the driver of the car just opens the car door negligently into someone standing there,
Well, that would
causing
not
them
be
to
the
fall
operation of
over.
a motor vehicle. That would not be. That would be opening a door while, maybe if the car was being driven and you open the door into them, I guess then the motor vehicle exception would apply. But if the car's stationary, no. When the car is stationary or the truck is stationary, it is not being operated.
Based on the judicial definition of operation.
Based off what the Supreme Court has told us, yes.
So is it your position that the whole entire vehicle has to move somewhere?
That is how the Ohio Supreme Court has defined the motor vehicle, applied the motor vehicle exception. So yes, it has to involve the movement of the motor vehicle. And when it's equipment that's attached to the motor vehicle, that is not the motor vehicle.
So
that is the
moving a
equipment.
part of the vehicle is insufficient from your perspective?
If it's equipment that's on it, and here the Packer body would be equipment like a big shovel on an excavator or whatnot, that if the car is stationary, or if the truck is stationary, in this case, all the expert testimony is it had to be. They tried to get it to the point where you could actually operate both the Packer body and the vehicle at the same time. It took two engineers doing things that should not be done, and safety features said nope and cut it all off.
And I'm going to fine tune what you're saying to see if you agree with me. When that, and I'm going to say motor vehicle, despite the argument of RRR, when a motor vehicle is moved, and then it's stationary, and then it's moved after that, and it's all one contiguous event, that whatever occurs when it's stationary is not operating of the motor vehicle. Is
It
that
is
what
not.
your arguing is?
That is my argument. That's based off of what the Ohio Supreme Court's definitions are.
Are we supposed to interpret laws narrowly in favor of immunity?
You have to read the words that the legislature has given us, and when you look at how they've been applied by the Supreme Court, they have said you use those words, and if it comes down to splitting hairs, you split the hairs. And this might be a hair-splitting case, but the way the law has been written, and based off of the cases that existed before 2744 was enacted, is that the legislature, if they wanted to make the operation of equipment matter for the motor vehicle exception, say that, no, if you're operating equipment, that's the same as operating a motor vehicle, they could have. They did not.
And your position, just so I'm clear, we do have a time where this truck is in motion, and it's when it's backing up into the working face. But your position is that that's not enough to trigger
That
the
is not what-
exception
right.
because that's not what caused
That
the
did
injury?
not cause the injury. The backing into the spot did not cause the injury. What caused the injury was when whoever engaged the packer body to eject the trash. That is what caused the injury.
And this isn't why isn't this one course of events? The backing up, the ejection of the trash, and the injury?
Because when the vehicle was not being operated and could not be operated when the trash was being ejected. And if the vehicle could not and was not being operated when the injury occurred, then the motor vehicle exception does not apply.
Why is the backing up not the proximate cause of the injury?
Backing up didn't, again, if backing up had caused the injury, if when the truck backed up, it had struck somebody, then that would have been a situation where it would have been the negligent operation of the motor vehicle.
But for the backing up, there would not have been the injury.
In Copen, but for the driving away, the person may not have been injured. And again, the Supreme Court has looked at this very specifically and said you look at when did the injury occur, and the injury occurred here. The allegations and all the evidence are that the injury occurred when the trash was ejected from whatever city truck it was.
I want to give you another hypothetical.
Sure.
A city-owned vehicle drives up to the back of a building and parks there, and in doing so blocks the exit to that building. Some people are trapped inside and they die because they can't get out. Do we have operation of the vehicle? Is there causation?
There might be some other exception to immunity that would apply, but the motor vehicle exception would not apply. The motor vehicle exception is designed, again, really to deal with common traffic accidents, and it deals with the operation of a motor vehicle. And no, I don't think that again, some other exception may apply. I would have to look into that a little bit more. But as far as the motor vehicle exception, the motor vehicle exception wouldn't even be relevant because the vehicle wasn't being moved at that point.
Thank you for your argument this morning.
Thank you very much. I ask that you affirm.
Thank you, Your Honors. I'd like to start where you left off. Your Honor, your example of the bus door is exactly right on. There's no reason to not have the exception apply when someone's injured by the door moving as opposed to when the bus is moving. We still have operation of a vehicle, a motor vehicle, and someone's injured. The application should apply there. What my colleagues have argued is that, oh, this only applies to car crashes. Well, the old statute did, right? The one that said it had to be on an operation on a highway. That's not what this exception says. This exception says operation of any motor vehicle. It's a much broader concept than just car crashes on the roadway. Remember, the Supreme Court said context matters. So in this context, we have a dual-purpose vehicle. Every other vehicle that the Supreme Court has addressed has the only purpose of transporting people. The testimony is clear from the city that this has two purposes. One is transporting workers, but also transporting and injecting trash. So when you look at the context, you have to look at that when you address operation. Operation is both transporting people, but it's ejecting the trash, and that is the operation that we were talking about. Again, it's the backing in too close and at an angle, but it's also the movement, the operation that we talked about, ejecting the trash. The argument that this trash truck is two distinct components is just simply factually not true. They buy one thing, a garbage truck. If we're going to take every single component, then it's made out of thousands of components of every screw and nut and tire and brake pad. It is the truck that they bought. It's not separate equipment. And we know it's not separate equipment because they tried to operate the blade and move the truck at the same time, and they couldn't get it to work because there wasn't enough power for the engine to operate the vehicle and the blade at the same time. That means it's not separate equipment. It's not the separate equipment that Rec had. It's not separate equipment. It's all incorporated into that one vehicle. The questions about whether it was Mr. Jones, again, we have circumstantial evidence. There's only one driver that admits that he parked 3 to 5 feet away from another truck that day. There's only one driver that admits that when he was backing up, he saw the truck next to him as opposed to the open landfill. And there's no other driver who came forward and said, it was me. We have circumstantial evidence. That's why the jury has to decide, do we have enough evidence? My colleague brought up the Cites case. The Cites case actually is, there was 4 people smoking on the outdoor area, and one of them, the one that was sued, put his into a bottle, put his cigarette butt in a bottle, and that was the testimony from him. And so the court said, hey, wait a second, you don't have enough to prove that the person you sued is actually the one that caused the injury. When we talk about Rumpke, the argument presented here was the same argument that was presented at the trial court is, if we would have known that this was a premises liability case, we would have done something differently. We don't grant summary judgment because counsel misunderstood pleadings.
What alerted them to the premises liability aspect of the case?
What should have alerted them is the fact that someone came on their property and died, and we said because of things like a lack of a spotter, lack of directing traffic on the road, on the working phase. That is sufficient to put them on notice. Now, we have cited cases in our brief, like we did at the trial court and in the hearing at the trial court, that summary judgment based upon inadequate pleadings is not appropriate. There's a pretty good long line of cases from appellate courts in Ohio that say, if you don't understand the pleadings, you don't get summary judgment because you didn't understand the pleadings or they weren't pled correctly. That's a 12B6 motion or a motion for more definite statement. What we heard today, again, is what we heard at the trial court level, is that they thought it was a negligent landfill operation case. I don't know what that is. I've never seen the elements of that pled. They've never described what that is. They've cited cases, and those cases were nuisance cases, meaning the landfill brought in material and it leached into the water, or it blew into the neighboring property, or the smells interfered with people. No one died in those cases. No one died because somebody, improperly used a truck. Those are nuisance and environmental violation cases.
So let me ask you this. In looking at the complaint, and you're not going to remember these details, but under the first claim, number 9, you have this discussion about negligently operating the landfill by failing test spotters, proper traffic patterns, and/or visibility for drivers dropping off garbage. Is it that makes it enough for premises liability, or is it another part of the complaint that makes it enough for premises liability?
Yeah, so I think that is actually sufficient. There is other things in there, but what's not in there is the things that they've cited as to negligent operation, whatever this other tort is. There's nothing about environmental regulations being
So I want to
violated.
make sure I understood your answer, if you don't mind.
Yes,
Okay.
ma'am.
What you're saying is that 9 is sufficient to put the defendant on notice that this is a premises liability, in addition to the factual discussion that Jones had come onto the site.
Yes, and the fact that it's a wrongful death case.
Correct. Okay.
A couple things that I want to clear up. There was some discussion from Rumpke that in the 5 years that they looked in their database, they only found 8 incidents and no personal injury or death. Now, the reason they found no personal injury or death is the database only recorded property damage claims. It didn't record personal injury or death claims. It didn't record near misses. In fact, their employees were not required to report near misses. What we do know from some of the testimony is that witnesses, Rumpke employees, saw people actually engaging in fights on the landfill about who gets in what spot and you passed me on the road. They've witnessed situations where truckers or truck drivers have intentionally tried to back in, and they call it a short dump, which is they don't pull all the way in the spot. They pull halfway in the spot where the other operator might be on the side of his truck and try to dump on them. So we have that testimony in the record that those things happen, and Rumpke knows about it. What Rumpke has said is we have an inherently dangerous place. We know it's really dangerous because we've got big trucks and we've got big machinery moving around all the place, and we don't have to warn about that. But that's not their only duty. The landowner's duty is to make it safe or reasonably safe when they know about the danger. in so many premises liability cases, the argument is, we don't know about the danger. We didn't know that somebody dropped their thing on the floor. We didn't know that somebody spilled. They know of their danger, so they have to use ordinary care to make it reasonably safe. If the panel doesn't have any other questions.
What should they have done?
So our argument's very simple. Place a spotter who will direct people in and out. When they see somebody who backs in too close or at an angle, the spotter would say, hey, come back out, set it in. We ask every city driver, if a Rumpke spotter told you what to do or told you to move your truck, would you do that? Yes, we would. We believe they know what they're doing. Every city driver said that. If you've got a spotter there that day who says, hey, city driver, you're too close and you're at an angle, straighten it up, this accident doesn't happen.
Is there any evidence in the record that that's an industry standard?
So that is interesting. Rumpke could, the answer is no, and Rumpke could have put that in the record. They
Well, they would have negated that, saying that it's not an industry standard.
Correct,
Okay.
correct.
But you are the plaintiff.
Right. So remember at the summary judgment stage, they have argued that we can't bring a claim, and one of the ways they could have done that is bring an expert that says, you can't put spotters out there, you can't do that. We know that's not true. Now, the fact that we chose not to use an expert and they chose not to use an expert, those are litigation choices that are made all the time. This isn't a medical malpractice case where you must have an expert to talk about a professional negligence standard of care. We made the decision that we didn't believe that an expert was necessary to prove our case, and they chose not to do an expert either. That doesn't allow them to have summary judgment, nor does it make them allow them to have summary judgment based upon the fact that they didn't understand what the claim was pled in the complaint.
Thank you. Thank you for
Any
your
other questions?
argument this morning.
Thank you, Your
Are there
Honor.
any other questions from the panel? All right. Thank you so much. Thank you, everybody, for your arguments this morning and the supporting team for being here. We will take the matter under submission, issue a timely decision. Have a wonderful afternoon and a wonderful day. So we're now going to take the recess, and the students that are here from Simon Lazarus, just stay where you are. And if you want to move into a different spot, feel free to move as well. And then everyone else, I think you're going to be directed into another room, and there'll be other students coming in. Thank you, Renata.
All rise. Court of Appeals First Class District of Ohio is now